We have built our firm around one idea: to lead our clients from where they are to where they want to be. But the ability to deliver the leadership and service our clients deserve doesn't happen by chance. It's a product of who we are. We are engaged, diverse, and innovative thinkers who go above and beyond what is expected because we know our efforts will carry us to achievements others never thought possible. We are unafraid to take the necessary risks that lead to new successes. We embrace change because we know sound principles will guide us through new opportunities. We are committed to empowering our people, our clients, and our communities to become every part of what they aspire to be. We are persistent on our journey forward. It is our openness to collaboration, our desire to achieve better, our character, our vision, and most of all, our people that make us who we are. That's the HB difference. We are Husch Blackwell.
Hello, everyone, and thank you for joining us today. My name is Jessica Zaratsky, and I am a partner in Husch Blackwell's banking and finance practice in the Milwaukee, Wisconsin office. Before we begin the presentation, we do have a few housekeeping items that we need to cover. First, at the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please feel free to submit those via the question box, and we are going to try to answer all of your questions at the end of the presentation. But if a fuller answer is needed or if we run out of time, questions will be answered later via email. Next, a PDF of today's presentation is available in the resource folder. And also, this program has been approved for legal education hours. And to report your hours, just click on the CEU icon on the bottom of the screen, and a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And we will have some poll questions and a survey for you at the end of the program. So we do encourage you to stick around so you can participate in those. And for those of you attorneys who are in attendance with us today, you can appreciate that we do need to make a quick disclaimer that the information we are providing during this webinar does not constitute legal advice and does not establish an attorney-client relationship. So that should be it for our housekeeping items. And then with that, we're excited to get started with the program. Joining me today is my partner, Buffy Klein. Buffy represents financial clients and institutions in areas of commercial litigation, commercial loan workouts, out-of-court restructuring, loan documentation, and the protection of creditors' rights. She advises several national clients in connection with the workout restructuring of their troubled loans. And we really appreciate this opportunity to talk with you all today about assessing and addressing at-risk credit facilities. We think that this is really a timely topic because in the early months of the pandemic, one of the main questions in the response to COVID-19 was, how do we get everyone through the first handful of months of uncertainty? Because we couldn't imagine that this would last more than a handful of months. And so the focus in those early months was really on the short-term solutions, the immediate needs, and the immediate fixes, all really in an attempt to stabilize borrowers and lenders, and with the hopes that these Band-Aids would be enough to quickly restore economic activity and minimize operational and financial distress. But here we are, almost 6 months later, and realizing that these short-term fixes were not enough, and we're starting to see the beginnings of the long-term effects on borrowers and lenders. For example, those short-term loan amendments and modifications that were put in place in March and April, and then maybe again in June and July, have expired, but the borrower's problems have not. And they're suffering from cash flow shortages, they're struggling to service their debt, and they're not in compliance with their loan documents. On top of that, they and we are all facing a new normal and an uncertain future. Some specific indicators of a borrower's financial distress, which you are probably starting to see, include aging accounts receivable and payable, decreases in accounts receivable, missed payments, and difficulties complying with loan covenants. Rising risk ratings and defaults have caused many financial institutions to start reassessing their credit decisions, including moving loans from the business lines to special assets groups. So in today's uncertain landscape, we believe that this is a good time to start identifying at-risk credit facilities and to perform any necessary due diligence. So with that as our backdrop, Buffy and I are going to give you all a high-level overview of file reviews, reservation of rights and default letters, pre-negotiation letters, waiver agreements, and loan amendments. And we're also going to touch on when forbearance agreements come into play, generally what they are, and also highlight some of the common yet important terms in that agreement. So with that, I will now hand it over to Buffy to begin the discussion on file reviews, reservation of rights, notices of default, and pre-negotiation letters.
Thank you, Jessica. Good afternoon. I'm Buffy Klein. I appreciate that introduction by Jessica earlier. I'm a partner in Husch Blackwell's Dallas, Texas office, and I practice primarily here in Texas and also in Florida. I have an opportunity to do quite a bit of litigation in Florida. So in both of those markets, I think we're seeing certainly a move toward what we were all anticipating, which is an increase in at-risk borrowers. What I wanted to talk with you today about was the first things that we do when we identify potential higher risk borrowers, and these are things that many of you have participated in the past and probably are aware of, but there's certainly important parts of the process as we are anticipating situations where we're having to renegotiate with some of our borrowers and to set them up for ultimate success is what we're wanting to do, and improve and maintain the position as a lender. The first thing to talk about is the file review, and this is important, and some may argue it is the most important part of this process once we've identified a potential at-risk borrower. And the key issues that you're going to be looking at in a file review is really to make certain that everything as the lender needs is evident. And these are things like whether or not your loan documents are actually appropriately signed and have been authorized. All the appropriate resolutions are in the file. The collateral used to support the loan facility, all of that is described accurately, and the appropriate securities agreements and UCC1 financing statements have been filed, recorded, they've been renewed, and also you've taken the opportunity to identify other potential issues with regard to the borrower. Have they filed their tax returns? Are there IRS liens? Have they paid all of their business property taxes, ad valorem taxes in Texas that are very important because they may be priming to a lender? Make certain that you've got the guarantee agreements in place and that they're executed and they're adequate. If you have a limited guarantee, those need to be reviewed and understand exactly what type of a guarantee is in place to support the credit facility. Take a look at the financial covenants that are already present in the credit facility and identify whether or not those remain adequate in today's circumstances, and whether or not the covenants that are being requested are relevant now, whether they give you the type of information necessary to really understand the financial health of your borrower. Also, it's important to confirm corporate status of the borrower, the guarantors, and any other principals. Identify whether there are other liens in place that you were not aware of before. And also identify whether or not the interest rates, any defaults or acceleration has been triggered by a breach of any covenant. And also, at this point, identify whether or not in the life of that credit facility, defaults have already been sent, reservation of rights have been sent, and if so, did they accurately reflect the situation at the time? Were they accurate? Is there anything that needs to be corrected with regard to those? The importance of this really can't be overstated. The results of this review is going to really direct the course of communication that you have with your borrower going forward. So once you've taken a look at that and you've identified any issues that are outstanding in the file review, I think that at that point you're going to want to put together a course of action that helps you to rectify any deficiencies there. This is also, once that review's occurred and the defaulting borrower or at-risk borrower has been identified, then rights or notice of default is also appropriate. When you're looking at these types of communications to your borrower, it's important to make sure that you've reviewed the loan documents and that they're being sent appropriately to the right parties with the right addresses in the correct manner. I think it's important also at this point to be specific, referencing the defaults, so that you know exactly what it is that you're talking about at the time of the default. Likely there'll be additional defaults that occur later, so you want to make certain that you're not necessarily overstepping, but that you're reserving any rights to call additional defaults later. At this point, it's important to note that the loan documents have and should remain unchanged, and the borrower should understand that. All the obligations that are present in those loan documents that have previously been executed are still in full force and effect. And you want to make clear that you're not establishing a course of conduct by any of these without formally modifying those loan documents. A lot of times you hear about these reservation of rights letters, pre-negotiation letters. The important thing to remember about this is that you're wanting to make it clear that you're willing to talk. These are the problems we see, but at this point we're not modifying or changing any agreement, and that will not be changed unless and until a written agreement is reached and it's executed by all the parties. One thing that we don't want to do is to open up that door so that to the extent on down the road they're going to be claiming that they were relying upon something that occurred at this stage when nothing in fact has changed from those loan documents. So now I'm going to turn it over to Jessica, and she's going to be talking about specifically as we get into the documentation and looking at changing that and waiver agreements and amendments.
Absolutely. Yes, two additional tools that a lender has in its toolbox in this context are waiver agreements and amendments. So anytime that the bank has agreed to a waiver, whether it be of a default or of a reporting requirement or some other loan covenant, it's important to document that waiver between the bank and the borrower and any guarantors to ensure that everyone is on the same page as to what this all encompasses. So with that in mind, a waiver agreement should, as Buffy was mentioning with respect to the reservation of rights letters and the default letters. Specifically identify the default, the requirement, or the other covenant that's being waived. So one example that comes to mind is stating, for example, failure of the borrower to deliver to lender its consolidated balance sheet and profit and loss statement for the fiscal quarter ending June 30, 2020, when identifying the default, is preferable to simply or generally stating failure of borrower to deliver to lender its financial statements pursuant to Section 2.1 of the loan agreement. Because with this latter statement, the bank runs the risk of inadvertently waiving all reporting requirements for all other periods that are covered under, in this example, Section 2.1 of the loan agreement, which the bank likely does not want to do. So extremely important to specifically identify those items that are going to be addressed via the waiver agreement. And then also similar to what Buffy was talking about, some of the points important in the reservation of rights and default letters, the waiver agreements should also contain statements that make it clear that this waiver is limited and specific to those items identified, that it's a one-time versus an ongoing waiver. The bank's waiver is not establishing a course of dealing or conduct, and then also containing a statement that the loan documents remained unchanged and in full force and effect. And then finally, it's also important for borrower and guarantor via this waiver agreement to provide a full release of lender of any and all claims that they may have against the lender to date. And then in the event that the bank agrees to move forward with an amendment to the loan documents in the context of a default that exists, many of the key provisions that I just discussed in the waiver agreement should be included in any amendment document. And then additionally, the amendment should specifically amend any applicable existing loan provisions, should have the borrower and the guarantor ratifying any existing and even possibly agreeing to additional representations, warranties, and covenants. And then should also identify any conditions that the bank is requiring in connection with the amendment, which could, for example, be payment of costs and fees, updated financial statements, updated collateral searches and verifications, and then maybe even a pledge of additional collateral and or other guarantees as appropriate. So having said all of this, there may be circumstances where waiving or restructuring or modifying the loan is just no longer an option, and a lender is left with no other choice but to call the default and put the borrower into forbearance. So with that, I'm going to hand it over to Buffy so that she can discuss for you when forbearance is the best choice and what advantages a forbearance can provide.
Oh, thanks, Jessica. So as Jessica was saying, forbearance, once you've gone through those interim measures, you've waived certain things to try to give a borrower an opportunity to catch up. You've provided some amendments that is limited so that you can allow the borrower to continue operating in as much a normal course as possible. Then you're looking at moving on to a situation where neither of those have perhaps brought you a fully performing borrower, and it doesn't look like it's going to happen unless something more drastic occurs or more opportunity is given to the borrower to try to modify. So this is when a forbearance really comes into play. And the question is, when is forbearance really the best choice? And really the decision to enter a forbearance agreement is probably going to be the better choice for a lender in a couple of situations. And the first step the first of those is when the problem appears to be relatively short-term. It's a cash flow crunch that looks like it'll even out. There's a seasonal business that typically has a history of righting itself given an opportunity. Those are the different types of examples that typically will be considered, as a short-term circumstantial problem that a borrower is experiencing. So those are the instances when, it's a short term, they have a plan, they're going to need to perhaps refinance the loan to try to change some of the terms. Those are the things that really need to be identified. So after completing the file review, the thing that you'll do is look and determine any deficiencies in the loan documents. What needs to be cleaned up before we enter into a further agreement? Because we're thinking at this point, there is at least a likelihood that there is potential litigation. Anytime you have a distressed borrower, there's a couple of things that are going to be looming potentially, and some of them we're seeing a lot more of lately, and that's bankruptcy. You are also finding people that are more litigious, because anytime you've got a distressed borrower, they're thinking of, every possible way to survive, and that includes essentially lender liability claims. So what the lender is going to look at is, what do they need to shore up their position, additional collateral, what documents need to be re-executed perhaps, what authorizations are missing that need to be obtained. And they look at this forbearance as an opportunity to give a little, perhaps with regard to interest rates, perhaps with regard to timing on payments, and then at the same time obtain a better position. Take a look at what type of additional collateral and whether or is available. Could those be taken as collateral? Could those be turned over to increase value? Those are the things that are going to really inform whether or not a lender goes in the direction of a forbearance. The advantages really of a forbearance can be enormous, because it does provide you with an opportunity for the borrower to acknowledge that they're in default, acknowledge the amount of money they owe, sign off on that. You've got that fully executed. It's current. You have, through this document, hopefully cured any of the deficiencies that you identified in your file review. You've obtained additional collateral. You've obtained additional guarantors, or expanded your current, perhaps limited guarantees. So this gives you, as the lender, an opportunity to try and improve your position, while also giving the borrower an opportunity to get back into a normal course of business. So really, the forbearance is designed to allow you to more closely monitor your borrower, be more involved, and increase the reporting the borrower may have to give you, and then also it also increases your leverage in the relationship. Hopefully, all while minimizing any potential additional risks you might have. So then I'm going to turn it over to Jessica. She can talk to you about some of the things we typically see in a forbearance agreement.
Absolutely. So jumping into some common terms of a forbearance agreement, it's first and foremost really important both in the whereas clauses and in the early provisions of a forbearance agreement to bring everything to the forefront, to set that stage and ensure that borrower and lender are on the same page when it comes to the key items at play. So this will be done via various acknowledgments, affirmations, and reaffirmations. And so the first is an acknowledgment and affirmation of the debt, where the current amounts of the outstanding debt are itemized, including principal and interest accruing at the default rate. and all other costs and fees, including attorney's fees. And borrower agrees that these are the current amounts outstanding. And then taking it one step further, having borrower agree that these amounts are immediately due and owing to lender without any defense, offset, or counterclaim. And one of the goals in doing this is to avoid or even resolve any disputes, whether now or that could pop up down the road as it relates to the amounts that are due and owing. Forbearance agreements could also and should also contain provisions where we have the borrower acknowledging and affirming the existing defaults and lender's rights and remedies as a result of those defaults. So as we discussed earlier, those defaults should be specifically and not generally identified in the forbearance agreement. And then borrower should go on to acknowledge that these specific defaults have occurred and are continuing, and that the lender is entitled to exercise its rights and remedies under the loan documents and under applicable law as a result of those defaults. The borrower should acknowledge that lender is not waiving the existing defaults or its rights and remedies, and that the lender is not obligated to make any additional advances under the facilities, but that if it does make those advances, the lender is doing so under a reservation of rights. And again, one of the goals with these types of acknowledgments regarding the defaults is to track the current and future defaults, and then to avoid future disputes or potential defenses relating to those defaults. And then third, Buffy is going to be talking about in a couple of minutes circumstances under which a forbearance agreement can be used to amend the existing loan documents. But we want to make sure that before we get there, those amendments are limited to only those explicitly identified, and that the forbearance agreement is not going to be viewed as a complete amendment of all the existing documents. So it's important as part of this reaffirmation is to have the borrower reaffirm and acknowledge that those existing loan documents, except to the extent amended explicitly within the forbearance agreement, continue to be valid, binding, and enforceable against the borrower in accordance with their terms and without any defenses. And that, furthermore, a lender has complied with all the loan documents and applicable law and has acted reasonably and in good faith. And then it's also prudent as part of this package of reaffirmations and acknowledgments from the borrower is to have the borrower reaffirm all of the representations and warranties that are contained in the existing loan documents as of the date of the forbearance agreement. So in other words, what we're looking to do in this regard is to bring those representations and warranties forward to the date of the forbearance agreement and reaffirmed. And then further importantly, talking about position with respect to collateral, borrowers should also reaffirm as part of the forbearance agreement the priority, the validity, and the proper perfection of the existing security interests and liens in favor of lender. And then I will now jump back to Buffy so that she can discuss some of the other forbearance terms and conditions, and then get into that discussion about amendment of existing loan documents in the context of a forbearance.
Thanks. So, I think to just recap a little bit about what we've been talking about, one of the goals here in entering into forbearance is to make sure that everybody's on the same page, and that the expectations and the relationship that's sort of put on new footing, everybody has been on the same page as to where they're going and what the expectations are. And the borrower and the lender are acknowledging that there's certain terms and perhaps conditions in the existing loan documents that are making it difficult for the borrower to stay in compliance. And so it's important for that success and for this relationship to get back to normal, for certain of these things, of the conditions and terms, to be modified. I think it's important, as Jessica stated, to make clear to the borrower that we're not whole cloth redoing this. This is not a new relationship. We're modifying certain parts of it so that you can try and become more successful and get yourself back into compliance. And this is that path to it. So as the lender, you're telling the borrower that you will forbear from enforcing your rights under those loan documents that are in default, and the borrower is acknowledging that it's going to benefit from that forbearance. So they're basically saying, we get it. We've not been in compliance. We're in default, and we understand, but we're asking that you forbear from enforcing our rights so that perhaps we can be successful again. And that representation and that acknowledgement from the borrower is important. Then the other issue that you want to make certain is that you've got a specified period of time that these terms and conditions are going to be effective, so that this is not going on and there's no question in the borrower's mind exactly how long they have under the new under this forbearance agreement. You want to make certain that you've got a specific period of time, and so long as no additional default occurs, you agree that you're going to let them to perform under these new terms and conditions for that period of time. So some of the amendments that you may see to the loan documents, or that you may need to make in order to to make the forbearance agreement work, and they're typical: the change in payment terms, what you're going to look at is perhaps changing the maturity date. So you may have a payment in full at the expiration of forbearance period. You may have an extension of the maturity date by a certain period of time, or you may also change your affirmative or negative covenants. For instance, there may be a covenant that they are going to have, some type of sales requirement, revenue of X. They may change. You may have reporting requirements that are going to change. Many times we see increased reporting requirements. They could be weekly. They may be monthly. They may be sales reporting. Other things that I've seen, you may have a request that you get, board minutes. I mean, you see all kinds of things in a forbearance agreement that keep the lender more apprised of the activities of the borrower on a regular and perhaps more frequent basis. You may have include a reduced loan commitment. There may be a reduction or a acknowledgement that there's going to be a faster payment with a smaller obligation. A freeze of a credit line may be also part of it, so that you have the borrower acknowledging that there is no obligation on the lender's part to provide additional credit. Other typical conditions that we see: a budget, so that your borrower is telling you, this is how much money that we're anticipating, and of this, these are my expenses that need to be paid, and everybody stays on the same page, so that there's so that the lender can identify exactly what to expect from in different circumstances. You may have additional documents that are executed that help to cure some of the deficiencies. Perhaps there was a lien that wasn't properly documented. You get the consent then to fix that or to file that. Additional guarantees, certainly consents and reaffirmations of guarantors of these new forbearance terms. The one thing that you're going to want to make certain too is that up at the beginning of this forbearance agreement, that there's evidence of authority to execute it, to deliver it, and to perform under it, so that any different resolutions that were required by their operating agreement have been complied with. Any additional collateral has been approved and all of the documentation necessary to support that has been provided. Some of the things that you may have heard of that we see pretty typically, there may be a workout consultant that comes in to provide additional guidance to the borrower. Often those will be, approval from the lender will be necessary, or there will be a pre-negotiated expertise that would be required of that consultant with regular reporting. There may be also identified assets that could be liquidated to provide more cash flow, pay down existing or outstanding loan balances. So those are all of the things that we see that are pretty common, different conditions that would be within a forbearance agreement. Obviously, certain jurisdictions have other things that are required. And even in some circumstances, we see payment of fees, especially legal fees, that are baked into these forbearance agreements. And typically a forbearance fee, because of the added oversight, may also be rolled into a forbearance agreement. So now I'm going to, let's see, I'm still going to talk to you some more about the other provisions. So we may also have in here, and this is something that these are different terms that we see that benefit lenders, because in the event of a default and the forbearance agreement isn't working, so the collateral is going to have to be returned, or be that the lender may have to exercise its rights under the loan documents or the forbearance agreement. So these are the terms that help to make that an easier process. So often we'll ask the borrower to waive rights to notice with respect to disposition of any personal property collateral. Under Article 9 of the UCC, certain notices are required, and certain of those, especially post-default, can be waived. We would also request a shortened period or a complete waiver of any redemption rights, so that to the extent there is an additional default or the terms of the forbearance are not complied with, then the lender then can move directly into exercising its rights and remedies in that collateral. We may also, and often do, ask that they agree to the appointment of a receiver to the extent that they are unable to perform, and so that they would have a pre-consent to that, so that when we do move for a court order, that we would already have that consent in the forbearance agreement. In many jurisdictions, you can also have them execute a stipulation to the entry of a judgment, and that can be for a foreclosure, or for the personal property, or for a deficiency balance. And so to the extent the jurisdiction that you're in allows that, those are certainly things that we would recommend including in a forbearance agreement. Also, there would be an acknowledgement of the lender's right to set off the borrower's bank account. And if you're a typical or a traditional bank, this is something that would be in your loan documents, and this would just be an additional acknowledgement that the right is there. The last provision we would ask, is there a waiver of the automatic stay? Certainly that would be helpful, although it is not necessarily going to prevent you from having to move for a lift of stay. It just is an indicator of their consent to that automatic stay lift if and when your borrower files for bankruptcy. So those are just different things that would be included in a forbearance agreement that, if the borrower ultimately defaults, makes it easier for the lender to move forward with exercising remedies. So now I'll turn it over to Jessica so she can address some of the additional issues and things that would be included in the forbearance.
Great. And yes, Buffy, I think you hit the nail on the head too when you were explaining some of these other provisions that can be included in the forbearance agreement to benefit the lenders, kind of some more customized provisions, is to stress, and you mentioned it a couple of times while you were talking, depending on the jurisdiction you're in, some of these provisions we will include in forbearance agreements, but also with the caveat language that, these are to the extent that they are allowed under applicable law, because it does depend and vary depending on the state, depending on whether or not you find yourself in the bankruptcy court with respect to your lender. And so while it's important to keep those in mind and put them in, it's also important to understand that there may be jurisdictions under which those will not be enforced, but we do try to put those in there with that qualifying language. Some of the other common yet important last points that we do not want to lose sight of in a forbearance agreement is a release, waiver, and indemnification by borrower and guarantors to the benefit of the lender. And so with these provisions, we look to have a borrower fully release the lender of any and all claims, including lender liability claims. And as also part of this, have the borrower fully waive any and all defenses to the loan documents and to repayment of the loan. And then further to have the borrower agreeing to indemnify the lender with respect to all liability related to the loan documents and to the forbearance agreement. But it is important to keep in mind that any of these such releases should only run through the date of the forbearance agreement, because a release of future acts could be viewed as overreaching and therefore unenforceable. So we don't want to get in a position where we're doing that and asking for too much. Finally, forbearance agreements should also have the borrower consenting to a specific jurisdiction and waiving its right to a jury trial. Again, I think the common theme that you're probably picking up here is that with a forbearance agreement, this is an opportunity to set that stage so that if and when a lender needs to pivot to a litigation strategy, it can hopefully do so without getting wrapped up in some of these other types of disputes that we were trying to address by way of the various terms and provisions and conditions of the forbearance agreement. So with that, it does look like we have a couple of questions that have come in. Buffy, I'm seeing a question as it relates to, let's see here, as it relates to the new subchapter 5 of the bankruptcy code.
Yeah, do you want to, why don't you address, John, the first question that we received, and then I can talk a little bit about subchapter 5.
Perfect. So we first have a question. Why would a lender agree to a forbearance agreement as opposed to simply a default and reservation of rights notification? Is there any benefit to the lender? And I think as we were discussing earlier today and kind of walking through some of those advantages that Buffy was talking about, is that with respect to simply a default and reservations of rights notification, that's coming from the lender addressed to borrower and guarantors. The forbearance agreement is an opportunity for the lender and the borrower to come to an agreement with respect to the current situation that they're finding themselves in, to have the borrower sign an agreement where they're acknowledging the defaults and that the lender is going to forbear and then the lender being able to reserve its rights while also continuing to build in some of these provisions that we've talked about, where the lender is maybe cleaning up some document deficiencies, maybe requiring some additional reporting requirements, requiring some additional collateral, increasing its leverage, strength, not only maintaining, but if it needs to, depending on the situation, strengthen its position and minimize its risks with respect to the specific relationship, so that you can ultimately collect on that debt as quickly and efficiently as possible if and when that time comes. So this is an opportunity for the borrower and the lender to come together in agreement that's signed by all the parties, addressing all of the needs, which a default and reservation of rights letter will not be able to do in that context.
Great. Well, thank you for that, Jessica. The second question that we received was with regard to subchapter 5. And I think this is an interesting new subchapter that was approved and went into effect earlier this year. And the question is, I'm seeing some information that some bankruptcy courts are allowing individual guarantors to use the new subchapter 5 of the bankruptcy code. Any special things for a lender to consider when dealing with an individual guarantor? So subchapter 5 is designed to be, for lack of a better reference, would be sort of like a Chapter 13 for bankruptcy, or for a business, so that you are acknowledging and it gives you a payment plan. The issue here is that to be eligible, the debtor is engaged in commercial activity, and the total debt, both secured and unsecured, of the debtor must be less than $7.5 million. Now, when the act was first, when it first went into effect, in January of this year, it was $5 million. But with the onset of the coronavirus pandemic and increasing in small business distress, this was temporarily increased to $7.5 million. I don't know that it'll go back down, but it certainly has made this more accessible to mid-sized companies. At least half of the debt, half of that $7.5 million, has to come from business activity. So if you've got an individual guarantor and they are guaranteeing business debt, both from operating or non-operating companies, and that is makes up more than half of their debt in total, then they would be eligible to file a subchapter 5 also. So I think that looking at that, it's not a ton different than if an individual were to determine they were going into a Chapter 7, but the difference is that they're going to be reorganizing and trying to modify their payments under the subchapter 5. And there is less opportunity from a lender to object to those the reworking of those payments, essentially under the code. So I think that as you're looking at this, just acknowledging that there is this new opportunity for people to utilize not going into a Chapter 7 liquidation, but really a reorganization under the subchapter 5. When you're dealing with an individual guarantor, it's important that you're really looking at the documentation. It's important that you're getting them to acknowledge the default, acknowledge the debt, and keeping up with it. I think one of the things that I see is oftentimes people kind of forget about the guarantees until they're in a default situation. And they may have entered into forbearance or modified, and all the notices haven't gone out to guarantors, for instance. You want to make sure that there's nothing to question their obligation there. We do actually have coming up next week an in-depth webinar on subchapter 5. It's being given by one of our partners in the Kansas City office, so that it will be set up very similar as today's program, but specifically on all the ins and outs of a subchapter 5. So I invite any of you with more detailed questions on that particular program to attend that, and certainly follow up with us if we can answer any specific questions.
And Buffy, just to follow up on that, it looks like that webinar is entitled Preparing for the Coming Wave of Small Business Bankruptcy Filings, and that will be noon Central Time on Thursday, September 10th, so next week, September, and again, a webinar similar to this format. So yes, highly encourage you all who are interested in this topic to register to attend that webinar.
So the next question that we have is discuss the positives and negatives related to using a forbearance of maturity default as opposed to loan extension or renewal. I think that one of the things that is interesting about a forbearance of a maturity default is that it does give you a very, it gives you an opportunity, you know, as we've been talking about, to improve your position, especially if it does look like you're going to be extending this on, and you don't want to, and you want to really have you want to maintain your accelerated position, perhaps. You want to maintain your defaulted position. So you don't want to enter into a loan extension or a renewal because you have some concerns about whether or not there is going to be success of your borrower. So if you want to maintain that opportunity to call the default and you want to get all of the other benefits of a potential forbearance situation, improved reporting, other things, so that, and perhaps waiver of notices and other things in the event they don't meet those deadlines, that would be a time to consider forbearance of a maturity default, you know, as opposed to just giving them that extension or renewing it. Again, you know, it's going to be dependent upon that file review to determine if there's issues that need to be corrected on your side. Another time of forbearance is good is really when you want to obtain that release and you feel like there may be some questions from your borrower on certain points. And that's when a forbearance may be helpful because it is an opportunity to negotiate a more fulsome release of any lender liability concerns that may be apparent in the file.
Yeah, and I completely agree with all of that, Buffy. And moving on to another question that we have, should a lender consider taking pocket deeds for real estate collateral as a term of a forbearance agreement? I think a couple of considerations with respect to pocket deeds are to think about the jurisdiction that you're in and the requirements related to real estate and taking deeds on that real estate. So thinking about that, one of the other considerations would be doing the due diligence that would be necessary for taking the deed to real estate. And then also with respect to it being a pocket deed is really very carefully and considerately crafting the trigger language in your forbearance agreement as it relates to that deed and being able to take that out and record that, making sure that there is no room for a disagreement as to what those triggers are or any sort of interpretation and difference of interpretation between borrower and lender, so that you've adequately and very carefully and considerately thought about those provisions and identified the context that you're taking the deed in and that you will take it out.
I think the only risk I would see in that situation would be when you do have a pocket deed, is, you know, to the extent that that people do things that are, you know, untrustworthy, you can't really prevent another lender from stepping in there and taking a position if you have agreed not to record. So it would be difficult for you to then come in and argue if someone, depending on the state you're in a jurisdiction, whether it's a notice state or whether or not you could argue that your deed crimes it. I think that would be the biggest consideration there, is how understanding that it may not be as valuable as you think it is in the event a second or third lender gets in there before you do.
Yeah, that's a really good point. And also, even if you have provisions in your loan documents, which the borrower agrees to not go ahead and put those additional liens on the property, there are, involuntary liens to think of. So while you do your diligence on the front end and maybe taking it, it will also be important for you as a lender, before you decide to use it, is to conduct an updated due diligence search as it relates to that property, so that you do make sure that you understand the position that you as a lender are taking when you decide to move forward with it.
We have one more question that's pretty interesting. What guidance would you have to provide regarding a good banking relationship where the business historically is profitable, but last year generated a loss? The bank has a line of credit to the business and the two main owners guarantee the loan. Last year, the guarantors took guarantee payments, and then this year, one of the owners sold their ownership in the business. Now the line of credit has matured, and the seller of his interest was not ever officially released. Can you maintain that guarantee? And there's a lot of issues in this one, but I think that primarily, if you've got a guarantor, especially in an instance like this, that's not been released, and depending on the wording of the guarantee, I certainly think that that guarantee, just because you sell, I can't tell you the number of borrowers I've had in the situation where the guarantor sold out. They think they're off the hook, but certainly they're not, because they were not released. Or a wife had signed as a guarantor, and then they're divorced, and she's no longer part of the business, but she's still on the guarantee, didn't get released as part of the divorce decree. There's all kinds of things that occur that you see where that certainly is a consideration. I would say that they're not released. They're still obligated depending on the specific wording of that guarantee, and it would be a point of negotiation as to how that would be treated and what might need to happen in order to get them fully released. Certainly, depending on whether or not they could meet the requirements with one less guarantor. But without having been released, they're still obligated under the line. Now, if you're talking about a completely new line, then there may be some question about what it would be they're guaranteeing. I think it would come down to the specific language of the guarantee. Jessica, what are your thoughts on that one?
Yeah, that's exactly my thought as well, is to take a good look at that guarantee, see exactly what the guarantee covers as far as the obligations guaranteed, and then to think about the structure of this new line or renewal, or however you're thinking about structuring it, to see if it is an obligation that would be covered under the existing guarantee.
I hope we were able to answer those questions, and I know they certainly, thank you for the questions, because they certainly do help to put what we've been talking about today into real life context. If you have any other questions on these topics and you would like to get in touch with Jessica or I, our information is contained in the materials, and I think we have a couple of fun things to do here at the end. For CLE credit in one of our jurisdictions, they require us to do polling questions. So to the extent you can stay with us, we would hope to get some additional information about you guys. Jessica, you want to do you want to drive the polls?
Sure. All right. So I think you should all see here on your screen our first poll question. I work in the following industry, and we've set up 3 different industries or an other if none of those are applicable. So if you all could please log in your response to this question. I'll give you a couple seconds to do that. Great, and here are our results. So it looks like the majority of you all joining us today are indeed in the banking and finance industry. Our next poll question is, does your organization have a special assets or troubled debt department group? Yes, no, or I don't know. Again, a couple of seconds for you guys to all log in your answers. And it looks like here again, the majority are that, yes, you do see that your organization does have a special assets or troubled debt department or group. And then last but not least, our last poll question here is, have you ever worked with or used a forbearance agreement? Wow, 100%. Yes. So good.
Pretty impressive.
So I hope, yes. So thank you. I hope that you then found this presentation to be a good refresher course for you as we move into this next time of uncertainty working with forbearance agreements. And then, again, thank you for joining us. We're a couple of minutes over here, but we appreciate your time. And again, thank you for joining us. Just as a reminder, with respect to the legal education hours, to report your hours by clicking on that CEU icon, and then you will see that certificate of attendance mailed to you tomorrow, along with a recording of this webcast that you can watch again, and you can feel free to share. And then also there'll be a short survey for you to complete here. We do appreciate and use your feedback so that we can plan future programs that are applicable to you and your business needs. So again, this concludes the webinar, and thanks again for taking time out of your day. Have a great rest of the week.